Well, the Quebec government says it will look at keeping Rona in Canadian hands. This is as Lowe's makes a play for the home retailer for a look at doing business in the province and its reputation for trying to keep companies in Quebec hands. We're joined by Yvan Allaire. He is the chair of the Institute for Governance of Private and Public Organizations. He's also a professor emeritus at UQAM, the University of Quebec in Montreal, and he's also a former board member at the Caisse de Dépôt. He is, of course, joining us from Montreal. Professor Allaire, thank you very much for joining us this morning. So let's start with this deal, and then we can start to talk about generalities of doing business in Quebec. Does it make sense for the Quebec government to intervene and to say that it wants to block a foreign takeover of Rona?
Well, I think the problem raised there is a Canadian problem. Once the board in Canada says no to a transaction, it means almost nothing. If it were in the U.S., a board says no to a would-be acquirer, that would be the end of it. So here we are in Quebec, a company which has a lot of affiliated merchants, a lot of suppliers. The board says no, it's not in the interest of the company to be acquired. And we know that if nothing else is done, it will be acquired by whatever the will of the board is. Now remember that in other circumstances, in Toronto, the Canadian financial players got together to prevent the London Stock Exchange from acquiring the Toronto Stock Exchange. And so we have in Canada a situation where the board is virtually impotent when faced with hostile takeovers.
Yvan, then what does that say about shareholders' rights if you are investing in a Quebec company?
Well, in a Quebec company or a Canadian company, it's the same thing. Shareholders have rights, but it doesn't mean that the board is without any power to use his business judgment when faced with a decision like this. That's what the Canadian Business Corporation Act says. That's what the Supreme Court has said twice, that the board can consider all aspects, all stakeholders in making decisions in the interest of the company, not solely in the interest of shareholders. And that's what has been askew in Canada, where the Securities Commission have designed procedures for takeover which virtually make the board of directors impotent.
Let's talk a little bit about the Caisse. The Caisse has a slightly different mandate than Ontario Teachers' Pension Plan or Canada Pension Plan Investment Board in that it is explicit that it's not just about investing for pensioners, but also trying to build the Quebec economy. How does that mandate factor into the way the Caisse looks at deals like Rona or other deals that may come along in the future?
Well, the meaning of that waxes and wanes according to the leadership of the case. If you remember, Alcan was acquired and the case didn't do anything, nor the Quebec government, by the way, because the board had agreed to the transaction. In a case, we almost privatized Bell Canada. The case joined a consortium and then dropped out of the race, and it would have been acquired by teachers and some American funds if that had gone through. So the case is very vigilant, usually, in trying to provide funds, making sure that there is risk capital available to new businesses, that there is capital to grow, and of course takes participation in companies, but it does in all Canadian companies given the size of its portfolio. So it is very attentive. It always looks for means to have an impact through its investment, but it is not a fund that tries to block transactions.
Yvan, I'm just going back to the Rona deal. What impact do you think the upcoming provincial elections has on how that deal is going to be handled? Well,
basically, I think what is going on is trying to come with a group of players to make a counteroffer or to have sufficient position to prevent a transaction, which again, I remember, is what was done with the Toronto Stock Exchange. So it is probably going on now. These players some of them are related to the government directly or indirectly. So there is a will to have the view of the board reflected in some actions. The Quebec election may play a role, but I think it's a marginal role. The reaction will have been the same if there were no election in Quebec.
Yvan, do you think an investor who invests in a major Quebec company like Rona or any other major Quebec company should be aware that things in Quebec are a little bit different than the way they're handled in the rest of Canada, or is it really the same thing? Should investors be wary that the possibility of them getting, a positive liquidity moment because a foreign acquirer can come in and take over their company, is that different in Quebec versus the rest of Canada, or are we being unfair to Quebec in thinking that it's different?
I think we are. I think the questions that are raised by this Rona transaction are raised in Toronto. I think I wrote about that. There is serious concern in Canada that we are totally a free-for-all for transaction by foreign companies without any protection and without the board being able to evaluate this transaction because they're essentially powerless. So it is a Canadian problem. It happens that this transaction is making it very clear, but remember that after Falcon Bridge and INCO and all the others, the federal government put together a working group chaired by Mr. Wilson, and some of the recommendations were along the line of what I'm saying here. So we have to review our merger and acquisition guidelines and the power of the board in Canada.
Now, I understand that Canadian law for takeovers, we've talked about this here on the show, Canadian law for takeovers is very different than takeover law in the United States. But when Rona went public, it knew that. Rona didn't used to be a public company. Why would Rona have gone public, or why would it not have brought in a dual-class shareholding system to prevent the problem that you're talking about, which is that anybody can come in and trigger a takeover battle?
Yeah, well, they tell me that's a mistake, I think, that they made, but they tell me at the time it was very difficult because it was an association of merchants. It was a cooperative, actually, which turned itself into a stock-listed company, and it would have been difficult to define who holds the dual-class share or the multiple voting shares. I don't know the details, but certainly it would have prevented that. But remember that in the U.S., all these laws in 30 states which give the power to boards to say no to transactions came at the end of the 80s, beginning of the 90s, after the wave of LBO takeover. So shareholders who had bought shares in those companies before that were now facing a situation where the law said to the board has the power to say no to a undesired transaction because it's not in the interest of the company.
Yvan, final question. Is there any move to change this legal situation in Canada, or are we stuck with this for a long time to come, maybe forever?
Basically, it's up to the Securities Commission, and that's why I'm pointing the fingers at them. They have the obligation, the duty, and I would say the responsibility to look again at what they've done and make sure that we have a situation where we, the boards of directors of companies, can use their business judgment when faced with such attempts to take over the companies.
All right, we're going to leave it there. Yvan Allaire, thank you so much for joining us this morning.
Thank you.
That was Yvan Allaire. He's the chair of the Institute for Governance of Private and Public Organizations. He's also a professor of the University of Quebec at Montreal. He's also a former member of the board of the Caisse de dépôt.